I know that there's going to be perhaps some lively discussion in regards to this legislation.
And Senator Frank Uggan Jr. was right. Today, lawmakers tackled his Bill 195 that sets to protect infants who are born alive as a result of an abortion.
Therefore, this act mandates that healthcare providers give medically appropriate and reasonable life-saving and life-sustaining medical care and treatment to all born alive infants.
Uggan says Bill 195 was introduced in a prior legislature and is modeled off a template that has been utilized by over 25 states enacting born alive protection acts. One of the biggest concerns raised during the public hearing was the criminal penalties imposed to medical professionals. Specifically, the measure outlines that any physician, nurse, or other licensed healthcare provider who fails to provide reasonable and medically appropriate care to an infant in the course of an abortion shall be guilty of a criminal homicide.
My response during that conversation was, yes, the provision provides for it, but my perspective is and will be during the course of this discussion and has been for my entire life, is that if that infant comes out alive, that infant is a human being, Madam Speaker, and that infant should be cared for and tended to like any other human being.
It was also during the public hearing where legal and medical professionals not only called the bill unnecessary, as Guam and federal law already protects born-alive infants, but it diminishes the medical profession. Senator Ben Pangilinan agreed with the testimony.
And I don't believe that it's balanced, and I don't believe that it renders anything additional, with the exception of putting members of our community at risk.
He adds Bill 195 doesn't advance the in place.
This takes us back to those dark days and back alleys, when doctors, because of what we are proposing in here, are no longer going to feel comfortable or may want to place everything that they've worked for all their lives at risk to provide what is constitutionally a right to that woman to get professional medical care in her decision of what to do with her pregnancy.
Meanwhile, according to Uggan, the federal Born Alive Infant Protection Act only applies in limited circumstances. For example, he says the federal provision would only extend to those hospitals and employees operated by the feds or receive federal funding. It would not, however, prohibit private or state operating clinics and hospitals from denying care or medical attention to born alive infants. Bill 195 was eventually sent to the third reading file. Reporting for Guam's News Network, I'm Ken Quintaniza.